This week I want to discuss with you another golden oldie if you want. It's called Boulez versus Commissioner of Internal Revenue, and this is a case that led to double juridical taxation. And I want to talk about this case first, and then I'll go over some more recent cases from the Dutch Supreme Court which dealt with juridical double taxation or potential juridical double taxation as well. But let's start by looking at Boulez. Now, a summary of the facts. Pierre Boulez resided in Paris, France at the time of the petition. He was a citizen of France, and during 1975 is when the year of assessment was. He was a resident of Germany. For 1975, he was a non-resident alien of the United States. And so what was he doing in the US? He was a world-renowned music director and orchestra conductor. On 19 February 1969, he entered into a contract with CBS Records, which was a UK company, but a UK subsidiary of a US company actually. And the contract said, among other things, that during the first 2 years of this agreement, Boulez will perform for the recording of satisfactory mastery recordings sufficient in number to constitute two 33 1/3 RPM recordings, those old vinyl records, right? Or their equivalent, and they will record the performances for that music. And then it also said during the payment of the agreement, you will not give or sell your services to any other person, but and you will not perform during a period of 5 years after the expiration of the term of this agreement, give or sell your services for the purpose of making or assisting in the making of records. So Boulez was hired to conduct for some orchestras, and then they would record it and they would sell the records for a period effectively of 10 years. 5 years would be recording, and 5 years afterwards he couldn't make any new records. That was what was going on here. And he also acknowledged that his services are unique and extraordinary. He was, after all, world renowned. And then finally, it said all master recordings recorded here under and all matrices and phonograph records manufactured therefrom, together with the performances embodied thereon, shall be entirely the property of CBS Records. None of that belonged to Boulez. That is very common. If you write a book, for instance, publishers would say that they retain the copyright, for instance, as well. And then finally, under paragraph 7a of the contract, it is provided for your service rendered hereunder and for the rights granted to us herein, we will pay you the following royalties, important royalties. There then followed an elaborate formula by which the petitioner was paid based upon a percentage of the retail price derived by CBS Records from the sale of its phonographic records. And in all cases, however, the payment of royalties which the petitioner was entitled to receive were dependent on the future sales. So the more they sold, the more royalties Boulez would receive. So what happened next was that Boulez reported the income from these royalties in Germany, where he was resident, because he received royalties. But the US tax authorities said, no, what you received was income for services, and the services were provided in the US. Therefore, you should be taxed in the US and not in Germany. And the case went to MAP, but the German and the US authorities couldn't solve it, and then Boulez went to court, and this is where we are now. So the petitioner contends that the payments made to him in 1975 by CBS were not taxable in the US because they were royalties. Now, why does he say that? He says so because, as we saw, the contract calls it royalties, right? And if you look at what the treaty said, this is Article 2 of the very old format treaty, but of the applicable German US treaty at the time, it said any term not defined, otherwise defined, shall, unless the context otherwise requires, have the meaning which the term has under its own applicable law. So this is for the contracting state, the Article 3.2 as we know it. You first look at what the treaty says. If the treaty gives a definition, you use that definition. If the treaty doesn't give a definition, then you go to the laws of the state of which applying the treaty, right? So, but Article 8 of the treaty is very clear. It says royalties derived from a national person in the Republic of Germany shall be exempt from tax in the US. And the term royalties mean, and then if you look at my highlighted text, means any royalties paid as consideration for artistic works. Now, Boulez's performance as a conductor was an artistic work. That is at least what I would argue, right? So I would argue that there is quite a clear definition in the treaty. Does not mean I'm right. The judge wrote, acknowledging that the provisions of the treaty take precedence over any conflicting provisions of Internal Revenue Code, which is totally right, we must decide whether the payments received constituted royalties or income from personal services. This issue involves two facets. First, did the petitioner intend to license to CBS Records a property interest in the recordings he was engaged to make, which would give rise to royalties? Second, did the petitioner have a property interest in the recording which he was capable of licensing? So did he have anything that he could license, right? And to be very honest with you, that's not quite the way I read Article 3A. To me, it says royalties means any royalties paid as consideration for artistic work. So if I go and do a performance and I get paid for the performance, that is a royalty. Or whether I am a movie star or whether I'm a conductor or whatever I am, whether I write a book. I mean, my contract when I wrote my tax book said that it is a royalty that I get. But this is not the way the case panned out. And remember, we already have Boulez subject to tax in Germany for receiving royalties, right? The judge says, the US judge, the contract between parties is by no means clear. On the one hand, the contract consistently refers to the compensation which the petitioner is to be entitled to receive as royalties. So the contract calls it royalties. And such payments are tied directly to the proceeds which CBS Records was to receive from the sales of recordings which the petitioner was to make. And that is normally the way royalties work, right? The more you sell, the more you earn. Both these factors suggest that the parties had a royalty arrangement. We bear in mind, however, that the labels which the parties affix to transactions are not necessarily determinative of their true nature. And then the judge goes and quote US case law. I'll get back to that. And the fact that a party remuneration under the contract is based on a percentage of future sales of the product created does not prove that the licensing or sale of property was intended. And again, quoting US case law. So the judge leans towards that this is not a royalty, and this goes further. He says, on the other hand, the contract between petitioner and CBS Records is replete with language indicating that what was intended here was a contract of personal services. Thus, paragraph 1 clearly states that CBS Records was engaging petitioner to render your services exclusively for us. It is understood and agreed that such agreement by us shall include your services as a producer and or performer. So are these services or are these royalties? The contract does not tell us. And the judge ultimately comes to the conclusion saying, considered as a whole and acknowledging that the contract is not perfectly clear on this point, we can conclude that the weight of the evidence is that the parties intended for a contract of personal services. In other words, the US can tax. Which is, I think, going through everything a little fast. The judge did look, he very much focused on this question of did Boulez own anything that he could license? Again, an author that writes a book gets royalties for the book, regardless of whether the publishing house that publishes his book agrees that the property rights of the book remain with the author, or whether the property rights of the book belong to the publishing house. And I find what is interesting about this case is the court didn't seem to ever look at which law governed the contract. Now, considering the fact that this was a Frenchman living in Germany contracting with a UK company, it is unlikely, it seems unlikely to me, that US law would have been the governing law of the contract. And one would think that if you want to interpret the contract, you would need to look at whichever law the contract is governed by, which the parties chose. But that does not happen in the Boulez A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Now the judge goes on and says the second question is a question of law, and the question is whether petitioner had a property interest in which he could license or sell. So the court here leans to what the US courts have said: you must have the property before you can license. The treaty is not explicit, and we have found no cases or other authorities which would give us an interpretation of the treaty on this point. Now I find this a little interesting. If we go back to the Vienna Convention on the treaty on the laws of treaties, and what it says about interpretation, it says the treaty shall be interpreted in good faith, which means that since the treaty is meant to avoid double tax, you should interpret the treaty in such a way that it doesn't end up in double tax, right? Which the court doesn't say anything about in its decision. And so the treaty shall be interpreted in good faith in accordance with the ordinary meaning given to the terms of the treaty in their context and in the light of its object and purpose, as we just discussed. Now, and then Article 32 says you can go to supplementary means of interpretation, but there are conditions. Recourse may be had to supplementary means of interpretation, including preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31. So if you want to try and figure out what the plain meaning is of the words, or to determine the meaning when the interpretation of Article 31 leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. Now, if we look again at the definition of royalties, the term royalties mean any royalties paid as consideration for artistic works. I don't see that as being obscure, ambiguous, or manifestly absurd. So I would have stuck with this and just said, well, you know, if the contract says royalties, then maybe this is royalties. But this is not what happened, as we saw. And the court, among others, considered before a person can derive income from royalties, it is fundamental that he must have an ownership interest in the property whose licensing or sale gives rise to the income. And then he quotes US law. The court has also adopted the definition of royalty as a share of the product or profit reserved by the owner for permitting another to use the property. Now, this is, again, when you write books, for instance, you will agree with the publishing house that they pay you 8% or 10% or 12% of the sales of the book as a royalty, regardless of whether the publishing house itself claims property rights of the book or whether you have the intellectual property rights of the book. So the courts held that in order for a payment to constitute a royalty, the payee must have an ownership in the interest or property. And then it goes down further and says in its definition of royalties, the treaty embodies the same fundamental concept of ownership. Thus, in Article 8.3, royalties are defined to mean amounts paid as consideration for property rights, is what the court says, but it's different from what I have highlighted here. And the court concludes, it is clear then that the existence of property right in the payee is fundamental for the purpose of determining whether a royalty income exists. What I find interesting is that the court has not once looked at the OECD Model Convention, right? And I acknowledge there's discussions about whether the Model Convention is part of Article 31, which I firmly believe, because I don't think any treaty negotiator thinks of anything else but the OECD Model Convention when they negotiate the treaty, or whether it is part of Article 32, so it's a supplementary means of interpretation. And then, of course, there is Article 3.2, which says that you can go to national law, but only if the treaty is not giving clear guidance by itself. So let us have a look and see what the OECD commentary says about Article 12 and royalties, if anything. And then we will also look at a few more cases from the Dutch Supreme Court dealing with juridical double tax, especially in the case of exit taxation.